Hi, this is Victor. I'm going to talk a little bit about hearsay evidence and the truth of the matter stated. Evidence Code 1200 defines hearsay evidence. Hearsay evidence is evidence of a statement that was made other than by a witness while testifying at the hearing and that is offered to prove the truth of the matter stated. In other words, just because a witness is testifying regarding what someone else said outside of court, that doesn't necessarily make it hearsay. There are many exceptions, but the one we're going to talk about today is the evidence must be offered to prove the truth of the matter stated. This is best shown by an example. Suppose that a defendant is on trial for murder. The prosecution is trying to show that the witness had ample opportunity to see the defendant. So they begin a line of questioning like this. Did you speak with the defendant? Yes. What did you talk about? Well, first we talked about the weather. He complained about how hot it had been. Then we talked about his kids. He has two girls. They both are involved in sports. They take piano lessons, the same as my kids. The prosecution asked, did you talk about anything else? Well, I remember we talked about his trip to Hawaii while we played cards. And of course, we talked about the card game we played. We played for several hours. Now, let's analyze these statements. The statements made by the defendant were obviously out of court, and they were statements that are possibly harmful to the defendant, but let's look at why. We're trying to show that the witness had ample opportunity to see the defendant. So they talked about the weather. He complained about how hot it has been. They're not trying to prove the truth of that. They're not trying to prove that it actually was hot. We're not trying to prove that the defendant actually had two girls, that they're involved in sports, or that they take piano lessons. We're not trying to prove the truth of the card game. What we're trying to show is that the witness had a long time with the defendant, spoke with the defendant for a long time, and had an ample opportunity to see the defendant. The questioning would probably then resume with something that becomes even more incriminating, such as, well, what happened then? And then the witness might say, well, he jumped up and shot my friend. But that's not hearsay either, because that's an action. What hearsay is concerned with is an out-of-court statement made other than by the witness while testifying that's offered to prove the truth of the matter stated. And all of these statements about the weather, sports, piano lessons, it's not offered to prove the truth of those things. It's offered to prove the opportunity for the defendant to be seen. Thank you.